Good evening, everyone. My name is Jennie from PCBet 22402P, reporting about the Section 4 Joint and Solidary Obligations. Article 1207. Article 1207. The concurrence of two or more creditors or of two or more debtors in one and the same obligation does not imply that each one of the former has a right to demand or that each one of the latter is bound to render entire compliance with the prestations. There is a solidary liability only when the obligation expressly states or when the law or the nature of the obligation requires solidarity. The first one, we have individual obligation, one where there is only one obligor and one obligee. And the second one is the collective obligation, one where there are two or more debtors and or of two or more creditors. It may be joint or solidary. In a collective obligation, there are two relations involved, that between the creditor and the debtors and that among the creditors and or the debtors themselves. Now, let's see the difference between joint and solidary obligations. In a joint obligation, each obligor answers only for a part of the whole liability and to each obligee belongs only a part of the correlative rights. Whereas in a solidary or joint and several obligation, the relationship between the active and the passive subjects is so close that each of the former or the latter may demand the fulfillment of or must comply with the whole obligation. Joint obligations is where the whole obligation is to be paid or fulfilled proportionately by the different debtors. This is the presumption in all collective obligation unless solidarity is expressly stated. It means that an obligation of one person against another shall only be performed by the former even though there are other persons who have contracted with the obligee, same as the obligor's terms and conditions, it will still be performed individually. And the nature of the obligation in this case is separate and distinct from that of the other person. And remember that joint obligations is to each his own. Joint obligation is the general rule, while solidarity is the exception. And the presumption is a joint obligation in the absence of express stipulation of solidarity. And joint obligation is burdensome. A solidary obligation is one where each one of the debtors is bound to render and or each one of the creditors has a right to demand entire compliance with the prestation. Let's have an example. Jackson, Bam Bam, and Mark are liable to J-Boom in the amount of 60,000 pesos, and it is stated that the corresponding share of each debtor is 20,000 pesos. We know that Jackson, Bam Bam, and Mark are liable only for 20,000 pesos each, and that J-Boom is not entitled to collect from each debtor more than his corresponding share in the obligation. Let's say that a month after, J-Boom, the creditor, demanded the payment from debtors Jackson, Bam Bam, and Mark, and Bam Bam paid 20,000 pesos as his payment for the said indebtedness. Now, J-Boom asked Bam Bam for the remaining 40,000 pesos for the indebtedness of the other two. The question is, can J-Boom ask for the performance of the whole obligation? The answer is no. J-Boom cannot ask Bam Bam to settle the remaining 40,000 pesos because the obligation shall be separate and distinct from that of the other obligors. Debtors Mark, Bam Bam, and Jackson are distinct debtors, so J-Boom cannot demand payment from either one of them to pay for the whole amount. In terms of the joint liability, each debtor is liable for his own debt and each creditor can only collect that which is due to him. Words used to indicate joint liability are mancum, mancomunada, mancomunadamente, pro rata proportionately, pro rata jointly, and we promise to pay. Article 1208. Article 1208. If from the law, or the nature or the wording of the obligations to which the preceding article refers, the contrary does not appear, the credit or debt shall be presumed to be divided into as many equal shares as there are creditors or debtors, the credits or debts being considered distinct from one another, subject to the rules of the court governing the multiplicity of suits. In solidary obligation, there are two or more debtors who owe the same thing to the same creditor. That means there are two or more creditors entitled to the same obligation or to the same liability. Each debtor may be held liable for the whole amount or be compelled to pay the whole obligation, and each creditor may collect the whole amount. This may become a bit confusing, but take note that an obligation is solidary if the whole obligation can be performed by either of the obligors. If the whole obligation consists of several obligors, the performance may be performed by either of the parties. Words to indicate solidary liability are mancomunidad simple or mancomunidad and mancomunidad solidaria. Other words used to indicate solidarity are severally, jointly, solidaria, in solidum, solidary, together, and or separately, individually and or collectively, juntos o separadamente. I promise to pay, signed by two or more persons. It has been held that the words individually and jointly create a solidary liability. Solidary obligations may be used interchangeably with joint and several or several. Usage of the term joint and solidary is confusing and ambiguous. Let's have an example. Jisoo, Rosie, and Lisa are jointly liable to Jennie in the amount of 90,000 pesos. Now, in their undertaking, they bound themselves to pay jointly to Jennie the full amount of 90,000 pesos. Let's say that Rosie already paid 30,000 pesos for her share, and Jennie would ask her to pay for the remaining amount. The question is, can the obligee, who is Jennie, ask for the performance of the whole obligation? The answer is yes. Take note that if you saw the word jointly, solidarity, or severally, it means that they undertake to be bound solidarily to pay the whole amount, but of course with the right to reimbursement, or the act of repaying a person who has spent or lost money. So in this case, Rosie can ask Jisoo and Lisa for the reimbursement or pay their part. According to the parties bound, A. Passive solidarity or solidarity on the part of the debtors. B. Active solidarity or solidarity on the part of the creditors. And the last one is mixed solidarity on the part of the debtors and the creditors. In passive solidarity or solidarity on the part of the debtors, where any one of them can be made liable for the fulfillment of the entire obligation. Its characteristics are plurality of debtors and unity of prestation. It is in the nature of a mutual guarantee. Example, Yeji and Yuna are solidary debtors of Leah in the amount of 10,000 pesos. There is here only one debt, the debt of Yeji and Yuna in the amount of 10,000 pesos, and one credit, the credit of Leah in the amount of 10,000 pesos against Yuna and Yeji. Leah may demand payment from either Yeji or Yuna or both of them simultaneously the whole obligation. Payment by Yeji extinguishes the obligation, but Yeji may claim from Yuna the share which corresponds to him depending the agreement between them. In any case, Leah cannot collect more than 10,000 pesos, which is the extent of his credit. Under their contract, either Yeji or Yuna will pay Leah 10,000 pesos. Here, the debtors are named disjunctively or in the alternative. Their liability in Solidary and Leah can demand payment from either of them unless it clearly appears that the intention of the parties is that either Yeji or Yuna may pay without right of choice on the part of Leah. Active solidarity or solidarity on the part of the creditors, where any one of them can demand the fulfillment of the entire obligation. Its essential feature is that of mutual representation among the solidary creditors with powers to exercise the rights of others in the same manner as their rights. So example, Wendy is liable for 10,000 pesos in favor of Joy and Irene, who are solidary creditors. Wendy may pay either Joy or Irene. So long as the entire debt is not paid, Joy and Irene can demand payment from Wendy. If Joy received payment, she is liable to Irene for the latter's share in the credit according to their agreement. The liability of Wendy cannot exceed 10,000 pesos, which is the extent of his liability. In mixed solidarity or solidarity on the part of the debtors and creditors, where each one of the debtors is liable to render and each one of the creditors has a right to demand entire compliance with the obligation. So let's have an example. Hobie and Cookie are solidarily liable to V and Jean, solidary creditors in the amount of 10,000 pesos. Hobie can pay either V or Jean can demand from either Hobie or Cookie. The payment by Hobie of 10,000 pesos to V shall extinguish the obligation. Hobie can ask reimbursement from Cookie in the amount of 5,000 pesos or such amount agreed upon between them. V, in return, is liable to give to Jean the latter's share of 5,000 pesos or the amount stipulated. Remember that the agreement between Hobie and Cookie as to the extent of the share of each in the debt, or V and Jean as to the extent of the share in each in the credit, has nothing to do with the agreement between Hobie and Cookie on the one hand and V and Jean on the other. According to source, A. Conventional solidarity, or where solidarity is agreed upon by the parties. If nothing is mentioned in the contract relating to solidarity, the obligation is only joint. Legal solidarity, or where solidarity is imposed by the law. Example, if two or more heirs takes possession of the estate, they shall be solidarily liable for the loss or destruction of a thing, device, or bequeath, even though only one of them should have been negligent. So, example is Dayon and Nayon. Sila yung heirs sa company ng Twice, and then nasira ni Nayon ang candy bong na pamana pa ni God Gio. At dahil silang dalawa ang tagapagmana, liable din si Dayon kahit si Nayon lang ang may kasalanan talaga. Due to the damage, pwede nilang ibigay or ibenta ang kanilang property bilang kabayaran sa nangyari. Real solidarity, or where solidarity is imposed by the nature of the obligation. The law does not expressly indicate the cases where the liability in solidarity because of the nature of the obligation. The opinion is offered that the cases contemplated are those in which the intent or purpose of the law is to have the obligation satisfied in full, but the law itself does not expressly require solidarity. Article 1209. Article 1209. If the division is impossible, the right of the creditors may be prejudiced only by their collective acts, and the debt can be enforced only by proceeding against all the debtors. If one of the latter should be insolvent, the other shall not be liable for his share. Joint indivisible obligation. This article speaks of a joint indivisible obligation. The obligation is joint because the parties are merely proportionately liable. It is indivisible because the object or subject matter is not physically divisible into different parts. In other words, it is as joint as the liabilities of the debtors or rights of the creditors, but indivisible as to compliance. In a joint indivisible obligation, if one of the joint creditors makes a demand upon one of the debtors, there is no doubt that the debtor is in default with reference to the demanding creditor's share. The question is she also in default with the reference to the others? Although it would seem that the answer is yes, because this act benefits and does not prejudice the others, and therefore implicitly what the law provides. Still, it should be borne in mind that the creditors are still independent of one another, and therefore the answer should be no. Giselle, Ningning, and Winter are jointly liable to give Karina a car valued at 240,000 pesos. On the date of delivery, Giselle and Ningning are willing to deliver but Winter is not. In this case, Karina has no cause of action against Winter for the delivery of the car because, as a joint debtor, Winter is liable only for a proportionate part of the obligation, which is 80,000 pesos. Since the object or the car is indivisible, the debt can only be enforced by proceeding against all the debtors, for compliance is not possible unless they act together. The liability is converted into one damages. So Giselle, Ningning, and Winter will be liable for 80,000 pesos each, or a total of 240,000 pesos, which is the value of the car without increase of responsibility for Giselle and Ningning. Winter, the unwilling debtor, shall be liable for damages to Karina for having violated the obligation. If Giselle and Ningning suffer damages by reason of the non-fulfillment by Winter, they may recover them from Winter. Should any one of the debtors be insolvent, the other shall not be liable for their share. Karina must wait until the insolvent debtor, Winter, can pay. Article 1210. Article 1210. The indivisibility of an obligation does not necessarily give rise to solidarity, nor does solidarity of itself imply indivisibility. Example, Luna and Yana are jointly liable to deliver to Sevi a particular car, and let's say it is a Ferrari 458 Italia. Here, the prestation is indivisible but the liability of Luna and Yana is joint. We have what is called a joint indivisible obligation. If Luna and Yana oblige themselves solidarily to give the car to Sevi, we have a solidary indivisible obligation. The obligation is indivisible and the liability of Luna and Yana is solidary. To put it in another way, we have a solidary obligation, the subject matter of which is indivisible. In case of breach, even the innocent debtors are liable for the entire indemnity without prejudice to their right of action against the guilty one. A solidary obligation does not necessarily mean that the obligation is indivisible. Thus, where Luna and Yana promise in solidum to pay Sevi 10,000 pesos, we have an example of a solidary divisible obligation. Now, if Luna and Yana are jointly liable to pay Sevi 10,000 pesos, what we have is a joint divisible obligation because money is divisible. Article 1211. Article 1211. Solidarity may exist although the creditors and the debtors may not be bound in the same manner and by the same periods and conditions. Here, enforcement of the terms and conditions may be at different times. The obligations which have matured can be enforced, while those still in due will have to be awaited. Enforcement can be made against any one of the solidary debtors, although it can happen that a particular obligation chargeable to a particular debtor is not yet due. He will be answerable for all the prestations which fall due although chargeable to other co-debtors. Kinds of solidary obligation according to the legal tie. They are uniform, or when the parties are bound by the same stipulations or clauses, or when the debtors are bound by the same terms and conditions or stipulation. The next one is the non-uniform or varied, when the parties are not subject to the same stipulations or clauses, and when the debtors, while bound under the same obligation, like a loan, are not subject to the same terms and conditions of payment, but to different secondary stipulation or clauses. Example: Momo, Sana, Mina, and Chaeyong obliged themselves solidarily to pay Chewy 20,000 pesos as follows: Momo to pay by installment at the rate of 1,000 pesos a month to start in July, and Sana to pay in September, and Mina to pay in December, and Chaeyong if Chewy passes the bar examinations. In July, Chewy can demand only 1,000 pesos from Momo. Chewy can also make a demand from Sana, Mina, and Chaeyong the 1,000 peso share corresponding to Momo. But Chewy cannot recover yet the shares of Sana, Mina, and Chaeyong, which are not yet due and demandable. In September, Chewy is entitled to collect from any of the solidary debtors the share corresponding to Sana, which is 5,000 pesos, and Momo 1,000 pesos or 3,000 pesos. If Momo had not yet been paid any installment, the shares of Mina and Chaeyong are not yet recoverable. In December, Chewy can recover from any of the solidary debtors the share corresponding to Mina in the amount of 5,000 pesos, plus such amounts from the shares of Momo and Sana, which have not yet been paid. The share of Chaeyong will mature only after Chewy passes the bar examinations. And if Chewy passes the bar examinations, the obligation of Chaeyong to pay 5,000 pesos arises. This amount can be demanded by any of the solidary debtors. Again, Chewy is also entitled to recover all amounts which are already due, undemandable, and unpaid pertaining to the shares of Momo, Sana, and Mina. If the agreement of Chewy may demand the entire obligation from Sana in September, from Mina in December, or from Chaeyong if Chewy passes the bar examinations, then Sana is liable for 20,000 pesos in September, less the amount, if any, already paid by Momo and Chaeyong. Mina is liable for 20,000 pesos in December, less the amount, if any, already paid by Mina and Sana. Chaeyong is liable for 20,000 pesos if Chewy passes the bar examinations, less the amount, if any, already paid by Momo, Sana, and Mina. Joint obligation on one side, solidary on the other. An obligation may be joint on the side of the creditors and solidary on the side of the debtors, or vice versa. Example: Jungyun and Gio, joint debtors, are liable to Nayon and Dayon, the solidary creditors, for 1,000 pesos. Here, we have two separate debts of Jungyun and Gio of 500 pesos each, and one credit of 1,000 pesos of Nayon and Dayon. Nayon and Dayon can demand from Jungyun and Gio 500 pesos each only, the respective share in the debt. And Jungyun and Gio may be required to pay 500 pesos each, either to Nayon or to Dayon. In other words, Gio and Jungyun are not liable for more than 500 pesos each, and Nayon and Dayon is entitled to receive not more than 1,000 pesos. Assume that Jungyun and Gio are the solidary debtors, and Nayon and Dayon are the joint creditors. Now, we have one debt of 1,000 pesos of Jungyun and Gio, and two separate credits of 500 pesos each of Nayon and Dayon. Nayon and Dayon can demand 500 pesos each, their respective share in the credit from Jungyun and Gio, and Jungyun and Gio may be compelled to pay 1,000 pesos, which is the entire obligation. 500 pesos to Nayon and 500 pesos to Dayon. In other words, Jungin and Gio may be made liable for 1,000 pesos and Nayon and Dayon are entitled to receive not more than 500 pesos each. Article 1212. Article 1212. Each one of the solidary creditors may do whatever may be useful to the others, but not anything which may be prejudicial to the latter. Act of solidary creditor useful or prejudicial to others. A solidary creditor may do any act beneficial or useful to the others, but he cannot perform any act prejudicial to them. If he performs such act, and as a result the obligation is extinguished, he shall be responsible to the others for damages. As far as the debtor and the debtors are concerned, the act shall be valid and bindings, such as making of judicial or extrajudicial demands to the debtor and filing of complaint so that the obligation may bear legal interest. Any of the solidary creditors may do any act provided that it would be useful and beneficial for the other solidary creditors, but not anything prejudicial to the latter, such as novation, compensation, confusion or merger of rights, remission, or condonation. For example, Yeri owes Sulgi and Wendy, solidary creditors, the sum of 20,000 pesos. In this case, one of the solidary creditors, which is Sulgi, may make a demand from the debtor Yeri for the payment of 20,000 pesos. So, can we consider that as a beneficial to Wendy? The answer is yes, kasi ang makokolektang pera ay mapupunta sa kanilang dalawa. But in case of remission or condonation effected by Sulgi, the obligation will be extinguished, but since Wendy cannot be prejudiced by the remission, Sulgi has to reimburse Wendy for the latter share because Sulgi's act doing the remission or condonation is prejudicial to Wendy. Kasi pag nagkaroon ng remission or condonation, para na rin tinatawag na quits or donation na lang yung pera. So, hindi na magbabayad si Yeri, pero in that case, without the consent of Wendy, that is not useful or beneficial to the solidary creditor, ang liability na lang dahil si Sulgi ang nag-remit and nag-condone ng debt, ay liable siya to reimburse Wendy the amount of 10,000 pesos. Article 1213. Article 1213. A solidary creditor cannot assign his rights without the consent of the others. Assignment by solidary creditor of his right. In the absence of consent given by the others, a solidary creditor cannot assign his rights to a third person. The reason behind this prohibition is that each creditor represents the others, and the assignee may not have the confidence of the original solidary creditors, considering that the assignee, after receiving the payment, may not give the shares of the others. If the assignment is made to a co-creditor, the consent of the other creditors is not necessary. Effects of unauthorized assignment. This rule is unjustifiable and places an unnecessary restriction on the rights of the solidary co-creditor upon his share. The reason behind it seems to be that each creditor represents the others and therefore must have the confidence of the latter. But in the first place, confidence between co-creditors cannot properly be said to exist except in the case of a solidary credit by contract. In the second place, the representation of the solidary creditors is created by law and not by consent or agreement of the parties. If danger is seen in the possible misfeasance of the assignee, the remedy is not the paralyzation of the proprietary rights of the solidary creditor, but to impose upon him a subsidiary responsibility for the acts of the assignee, so that Article 1213 could have been made to read, a solidary creditor who assigns his rights without the consent of his co-creditors shall answer subsidiarily for any prejudice caused to the latter by the assignee in connection with the credit. Article 1214. Article 1214. The debtor may pay any one of the solidary creditors, but if any demand, judicial or extrajudicial, has been made by one of them, payment should be made to him. In this article, a solidary obligation, any one of the solidary debtors may pay the entire obligation to any one of the solidary creditors. This article articulates an exception that the moment one creditor demands, any solidary debtor paying must pay only to the demanding creditor. Payment to any of the solidary creditors. The rule is that the debtor may pay any one of the solidary creditors, but when a demand, judicial or extrajudicial, has been made by one of them, to avoid confusion as well as prejudice to the more diligent creditor, payment should be made to him. Otherwise, the obligation will not be extinguished except insofar the creditor pays share is concerned, in case the latter does not give to the other creditors their share in the payment. The demand has the effect of terminating the mutual agency among the solidary creditors. Article 1214 is applicable not only in cases of active solidarity but also where the solidarity is mixed, although the singular debtor is employed. In case of mixed solidarity, the debtor upon whom no demand has been made may pay any one of the solidary creditors. Example: Jisoo, Jennie, Rosie, and Lisa are solidary creditors representing the credit union in which Mr. GD is a debtor. If one of them or Rosie made a demand on Mr. GD in order to fulfill the latter obligation, Mr. GD can only make payment to Rosie, and that payment is sufficient to effect the extinguishment of obligation of Mr. GD. Dito naman, marami ang creditors, and kung sino man ang magdemand ng bayad, dun ka lang din magbabayad. And dapat yung payment isakto dun sa napagkasunduan nyo at dun lang matatapos yung obligation.